Hi, folks. I'm Denise Howell, and next up on This Week in Law, we've got a great panel including Tim Smith of MyWorks, Sarah Burstein, a law professor who specializes in design patents. We're going to talk about patenting chairs and pants, how to photograph trees with IP impunity. We're going to talk about tracking infringement and lots of issues involving intellectual property reform next on This Week in Law.
Netcasts you love.
From people you trust.
This is TWiT.
Bandwidth for This Week in Law is provided by Cachefly at CACHEFLY.com.
This is TWiL, This Week in Law, with Denise Howell and Evan Brown, recorded October 5th, 2012. Watching Patented Pants. This episode of This Week in Law is brought to you by ShareFile. Enhance your workflow. Send files of almost any size easily and securely with ShareFile by Citrix. Try ShareFile today. For a 30-day free trial, go to sharefile.com, click the radio microphone, and enter TWiL. Hello there, I'm Denise Howell, and you are joining us for This Week in Law, where we get together each week and talk about the latest and greatest and most controversial issues that affect your use of technology under the law. We do it with consistently great panels of folks, and this week is no exception. Joining us today from Norman, Oklahoma, is Professor Sarah Burstein. Hello, Sarah.
Hello, Denise.
It's great to meet you. You're over there at the Oklahoma College of Law. What do you teach at your law school?
Civil procedure and copyright.
And you're also quite a specialist in design law, are you not?
Yeah, that's what I write about, is design patents, trade dress, that sort of thing.
Well, there's certainly been a lot going on in the news about that. So we're anxious to speak with you about some of those issues. But first, let's introduce the rest of our panel. We've got Tim Smith joining us. Tim is the founder and CEO of MyWorks. Hello, Tim.
Hello. Thank you for having me on.
It's great to meet you. Tell us a little bit about MyWorks.
MyWorks is a long-term research initiative really focused on trying to what we call optimize intellectual property for the internet age.
Okay, well, we'll get into that in a little bit more detail right after we introduce Evan Brown from Chicago, Illinois. Hello, Evan.
Hey, Denise, how's it going? It's great to be back. I missed being on the show last week, but that was an awesome show that y'all did. I really enjoyed watching that. It was nice to take a week off and watch as a spectator. So really enjoyed it. But it's even better to be back.
Yes, it's wonderful to have you back. We missed you last week. I wish I had a bucket of tomatoes next to me here so we could continue sort of the tenor of last week's show, and I could hurl them at the camera from time to time.
And I could only imagine that there was quite a bit of activity in the IRC. Some of the things were, provocative to say the least. So I wish I could have see a transcript of what folks were saying in there, but it was really something.
It was funny. It was mostly, oh, no, he didn't, that kind of comment. So, but I was surprised that we had so much common ground, too. Among all of us on the show. So it was fun, and hopefully we'll have the same kind of violent agreement with each other this time around, but you never know. And we've got different topics to discuss too. Let's start out with a look at some stories that are in the realm of the entertainment industry. Okay, we obviously talked quite a bit about entertainment-related stories last week. We've got quite a few to look at this week as well. One of the things I'm most interested in that caught my eye recently is the extent to which a whole economy seems to be springing up around copyright management and enforcement. And Tim, your company is a species of what I'm referring to here. The stories that I've been seeing recently is relate to how much people are being tracked, how much infringement data mining is going on. and how many companies are springing up to fill that role, or have been filling that role kind of under the radar for a while. There was a conference in Padua, Italy. Sounds very Shakespearean to me, dealing, I think it was called Securicom, where some evidence was presented by researchers at the University of Birmingham in England that basically put out there that if you are using a BitTorrent client, whether it's, via Pirate Bay or something else, and you're downloading something that is among the top 100 torrents, your IP address is likely to be logged by copyright enforcement authorities within 3 hours. Now, nobody knows what, the ultimate impact of that data is, whether the data is being collected to whoops, sorry, just lost my mouse for a second, to facilitate more copyright lawsuits against individuals, or whether we're just tracking the universe, seeing how much infringement is going on or not. Evan, were you surprised at all about the extent of the data mining that's going on out there?
If there's anything to be surprised about in this, it would be the extent of it. I mean, the fact that it's happening should come as no surprise at all, because it's information, and certainly parties would have an interest in having this information, but it seems much more expansive than what I thought of. I mean, my introduction to this whole topic has been in coming into contact with clients who are John Doe defendants in BitTorrent file sharing litigation, mass copyright infringement lawsuits here. And so, we've known for several years that there's been some pretty sophisticated technology working behind the scenes tracking alleged infringements. But what we see now is a kind of an emergent property coming from the use of this technology to actually mine data from it, look at patterns, see what kind of marketable information is there. And it's interesting to see how, that data is being monetized and being used. And, and it lends itself to a number of different things, not only direct copyright enforcement, but also just a deeper understanding of what the market looks like, which hopefully could help us all shape better policies on, what the role of intellectual property should be, what copyright reform should look like in the digital age, where peer-to-peer technology and file sharing is really going to be more and more of a driving force in the distribution of content. So, it has consequences and effects in a number of different perspectives.
Okay, Tim, tell us a little bit. Your company has a slightly different role as opposed to monitoring, although if there is monitoring involved in what MyWorks does, you should let us know about that too. I wasn't picking that up from the descriptions of services on your site. You're more on the management side and sharing among coworkers. Is that right?
Yes. MyWorks is really, as I've said earlier, we're a long-term research project focused on trying to optimize intellectual property for the internet age. I've been involved in the past with companies that were not necessarily monitoring, but I understand the importance of monitoring. And this is really, we're still in the wild, wild west of this new paradigm. And the internet's been around for a long time, but there's still a lot of rules that are needing to be shaped. So what MyWorks is, the core of what we're trying to do is identifying who owns what. This is from my perspective, the fundamental problem that we have with intellectual property on the web. And it's because ownership information changes daily. It doesn't remain static. It's constantly changing because of things like people are going to die, people are going to get divorced, people are going to sell their properties. And because of all these things, it's hard to know who owns what. Recently resulted in a $300 million lawsuit between the Music Publishers Association and the Recording Industry Association because record companies didn't know which publishers to pay on the songs that were included on their records. It was a convenient excuse, not just necessarily an excuse, but it was really convenient because they could hold those monies and sit on them and make interest. So there was a settlement to the funds that were accumulating at the rate of about $100 million a year. And so they were settled for $300 million to to avoid these what this panel of judges determined would be a fair penalty, which was a 1.5% interest penalty per month for monies they held. So back to what MyWorks does, our long-term mission is to optimize intellectual property, and the thing we're focused on initially is trying to come up with a very efficient way of identifying who owns what in real time.
And do you specialize mostly in the music industry, or do you do other types of creative works as well?
Our initial focus, because we're in Music City, USA, and I have my partners have a lot of history in the music industry, we're doing a lot of pilots and initial marketing in the music space. But already we have customers that are signing up for a product called WorksProof, which is a third-party escrow proving that we substantiate evidence of the creation of a work, and we do it for less than the cost of a stamp because we're leveraging very cost-effective cloud disk storage. And we have people that are songwriters, record producers. They could be people that are writing books, people creating videos. So it's not just music. We were hired by the state of Tennessee to do some research on the optimization of intellectual property coming out of universities because they have the same problem. Academia is a lot of their work is done on a work-for-hire basis, but a lot of times they hire people to engage in development of new technologies that aren't properly documented, and it's questionable who owns the IP. So this who owns what problem crosses many verticals of the intellectual property markets.
Yeah, as you're talking about your service, about orphan works, literary orphan works, and that may be a problem too big for any one company to tackle, but it seems to be something that could ultimately be on your radar.
Yes, orphan works is a huge problem. It's talked about in many verticals. It's a problem in the music world. It's a problem in the photographic world. I think we're going to see it more and more again across all the core copyright industries combined.
Yeah, Denise, I'm glad you brought that up about orphan works because that's what I was thinking about when I first heard about MyWorks here and what it does here. And it seems like the problem with orphan works as they exist today, and Tim, I'd be interested in seeing what you think about this. It may be a problem where the works out there right now, they're just going to be orphans forever, and maybe only a small percent of those could actually have their lineages traced to their creators or copyright owners. It seems like what you're doing, making it much more systematic to track and manage these rights and to have a centralized place for their location would, as we go through time here, reduce the problem of orphan works so that 15, 20, 50 years from now, orphan works wouldn't be as much of a problem because of the technological infrastructure we're developing for managing them. Is that an accurate characterization or a realistic outlook on the future?
Yes, I think that's exactly right. I think because the concept of Moore's Law and how things are changing so rapidly and costs for disk space are coming down so dramatically, we're just one example of a resource that creators have that can come into a community and post works for free. And we gather really important metadata. This metadata of ownership and the collaborators on a work are typically not organized very well, and that contributes to this problem of orphaned works. So I agree with you. I think as technology continues to evolve, more and more people will become familiar with the way that they can create their work, store it on a free site. And, in the music space, a very small percentage of works that are created actually have commercial value. And so it creates a cost burden for somebody to try to log into the established systems that we have, like the Copyright Office. It's way too expensive to register work at the Copyright Office, and even the professionals only register the works that have become commercially viable. And the do-it-yourself market hasn't been educated yet to understand that concept. A lot of times the 700,000 works that are registered at the Copyright Office each year. Most of those are not commercially viable. So there needs to be some alternatives, like a precursor to the formal copyright registration process, and that's what we're advocating at MyWorks, and we're involved with the Copyright Office as a stakeholder in helping be a voice for some of the changes that are being anticipated by the Library of Congress.
Sarah, as you're listening to this, do you have any thoughts coming to you about either the tracking issue we discussed earlier or the marketplace for services like MyWorks that help people navigate the Byzantine maze that is copyright ownership and management?
Yeah, I think this MyWorks model is really interesting on a couple of levels. Just even thinking about how do you prove independent creation, right? Someone sends you a nasty letter saying you infringe my copyright. Maybe you could point to your MyWorks account and say, nope, hey, I wrote this song years ago. Interesting evidentiary issues, though, about how you would authenticate that and get it into court. When I was clerking, we saw issues with the Internet Archive, people trying to get evidence in. You might be prepared to be writing some affidavits if you get litigation down the line, because the courts will want to know how your product works, how you know the date, and how you can authenticate it.
That's a really good point, and we've done a lot of talking to legal experts, including one of the men who was the Register of Copyright, a guy named Ralph Oman, professor at Georgetown University, and his quote was that this is one of the this is great, not circumstantial evidence, but prima facie evidence. It could, and because we're a third party whose purpose is to act as escrow agent, we are prepared from a affidavit standpoint. We do all kinds of things technologically to store information about when things were uploaded and to make sure that the integrity of the files are maintained. But we also educate people that the best possible evidence, we say proof is the best protection. And it's kind of, when you take it into a legal context, it's not exciting to creative people. But what is exciting is was brought to mind. I spoke at a conference in Bilbao, Spain last year, and as I walked into the Guggenheim, one thing that really caught my attention was there was this early sketch that Picasso had done at a hotel in Paris of a work that 3-4 months later he finished when he went back to his studio. And as I looked at that, that's really what we're trying to do at MyWorks. We're trying to say, establish an early body of work that shows the history of the work as it's developed. And through our iPhone app, you can actually videotape the songwriting session and push it up to the cloud. And then 3 days later, you can record an audio version of the changes that you made. You can write out the text. And each one of those uploads creates this work history evidencing the work as it develops. We actually go to the point of grabbing geolocation so you can see where you were when you were creating the work. So there's over 7 different types of evidence that we establish for creators. And again, it's ridiculously inexpensive. We have partnerships with ASCAP, BMI, CSAC, the National Songwriters Association, where all of their members get dramatic discounts. So we're giving 50 megabytes of free copyright protection. And then as people spread the word for us, we'll give them additional free space. And then again, we say it's cheaper than the cost of a stamp. People used to mail themselves copies, and now it would cost 41 cents. Today, it would cost about 8 cents to upload a work, copy into MyWorks. So as these costs come down, then it becomes a tool that's available to a much, much broader market.
Hey, Tim, one last question about your company before we move on. I noticed there's a sharing component to what you guys do. And again, it seems to be more focused on collaborating between people developing the song and then distributing it. Do you see your service as a public distribution means or no?
It really depends on the interest of the content owner and the content creator. I mean, we don't care if it's a Creative Commons kind of a thought. If somebody wants to create a work and make it available to the public, that's their choice. If somebody is has a mindset that this is, I need to keep it really quiet. I have like an Apple mindset. This is going to be very private information until I decide that it's going to be maintained public. That's the choice of the individual. So we can accommodate both.
Do you see that? I understand that you're trying to create a framework that's more secure for distribution of files that people choose to share. Do you see somehow grabbing market share away from a I don't know. Well, MySpace comes to mind as still a place where musicians might choose to share promotional files. Do you see that kind of use of your service?
I mean, anything is possible, but what we're really focused on is developing the plumbing, if you will. We want to adopt metadata standards, and so many of the people who really don't have the years and years of experience in managing intellectual property don't understand the nuances of ownership metadata and how it changes. So we're really focused on developing that platform to do that. And then we want to develop the plumbing that can send that information to any of these discovery platforms. So we don't necessarily see ourselves being a discovery platform. We see ourselves more as a intellectual property management, and then giving the person the efficiency of putting their information in once and then shooting it out to all the sources that need this data. And then as it changes, as ownership information changes, we can eliminate the burden of them having to go back to 20 supply chain partner channels and have to update all their databases. So that's more along the lines of what we're thinking is we want to do this boring back office metadata management and then share it with supply chain partners that the content owners and creators believe are important to the discovery and marketing and licensing of their content.
Oh, we all know metadata is glamorous, so that shouldn't be all back.
So sexy.
That is, yeah, metadata. That's sexy. That's hot.
Well, it's neat to think of having a standard for creative works where, these evidentiary points of confusion could be reduced. So it's great that you're doing this, and we're really interested to see where it goes and wish you well with MyWorks. How long have you been around?
MyWorks started in 2008. We raised our first bit of capital in 2008, and again, we thought we were doing a startup, and we discovered about 6 months in we're really early stage R&D. Although we do have some products out there that are live, the R&D process is extensive, and it continues.
All right. Well, good luck with it all. Let's get to some more items that have been in the news recently. Let's talk about false positives for a moment. We've got a couple of points on that front. Number one, in the suit by Hotfile against Warner Brothers, EFF was permitted recently to file an amicus brief. This suit involves Warner having sort of back-channel access to files on Hotfile, cooperatively with Hotfile, but abusing that access, according to Hotfile, that they repeatedly took down files that were not infringing in any way, and including game demos, open source software, and were slow and not responsive in reinstating things when Hotfile or the file owners complained that their works were being removed. And so EFF has come in and is trying to say that even though Warner says, oops, sorry, we made a mistake, but really it wasn't our fault and we didn't intend to do anything wrong here, EFF wants their feet to be held to the fire, that there should be some kind of standard that you can't just, if you're working you can't just willy-nilly pull things down because it's easier to do it that way. You can't be overbroad. You have to pay more attention. Evan, what do you think about this?
Well, I think the EFF's position is reasonable here because it's inherently troublesome if there's going to be some back channel stuff going on that takes it out of the context that we're used to operating in with the DMCA and the ordinary takedown mechanism. I think even though it's not frequently used. Or at least not frequently used with much success, there's the penalties that one can be subject to if for sending a DMCA takedown notice that's not in good faith, under Section 512F. So these kinds of back channel communications like this are troubling in as much as they take it out of that context, and so we run the risk of there being overreaching on the part of the copyright holders. But the countervailing position of all this is that these are private parties dealing with one another, the record companies and YouTube. So, shouldn't they be able to do whatever they want to do? That's the opposing position on this. So, it's good to see that the EFF's involved in the dispute to kind of add some insight into all this and put forward a pretty meaningful and important position in that is representative of an important interest in all of this.
Let's see, Sarah, any thoughts on this one?
I agree. This isn't my area of specialty, but there's something deeply troubling about this idea that you can just over-enforce to such a dramatic extent. First Amendment concerns on top of just the copyright overreaching.
Absolutely. Well, it looks like YouTube is deciding that they have been called to the mat for this too often, that they've had high-profile instances where videos that should have stayed on the service were taken down via the automated function of their content ID system, which again is done cooperatively with some 3,000 large media publishers. YouTube is not going to let that continue, it looks like. In any event, they are changing their algorithms to hopefully eliminate some false positives. At first, there was some thought that they were going to, and I'm reading David Kravitz's piece over here on Threat Level, that they were going to start manually reviewing some of the content ID challenged materials. It doesn't look like, in their subsequent blog post, they clarified, it doesn't look like they're going to be doing that, but their algorithms are going to be tweaked so that hopefully the false positives will be less common. And once someone has challenged a content ID match, YouTube is going to hold the rights holders to their obligation to file a DMCA takedown notice at that point, or release the block on the material. So they're going to have to fish or cut bait as soon as the person who posted the video decides, oops, this should not have been subject to content ID. This was a mistake. This has happened to our network quite a few times. So hopefully this will help get shows reinstated quickly. Sarah, you think this is a good thing?
Sounds good to me. More procedure, putting the burden on the rights holder or the rights claimant. Doctrines like fair use are tough. Again, the First Amendment concerns are a big deal. So putting the burden back on them sounds like that's exactly where it should be.
All right. Tim, what do you think about this? How do you feel about content ID in general?
Well, I think it's a major step forward. There was, for so long, we had this, the DMCA was enacted in 1998. Here it is 2012, and piracy has had free reign for over a decade. So it's about time that we've put some technology in place to do this proactive identification. And I think it's a great step. We're showing good faith on YouTube's part. And so when possibly, I don't know what the numbers really are, but when an occasional false positive pops up, I'm not so concerned about it as it's like, well, maybe I don't think the pendulum has swung quite the other direction as dramatic as it did when piracy was so rampant. So I think they're doing a good thing, tweak their algorithms, make it more accurate, and then make it a little bit faster.
Yeah, accuracy is always good, and false positives don't help anybody. They don't help the rights holders who get themselves in terrible PR pickles when, the First Lady's video or NASA's video is coming down because of the content ID system. And they certainly don't help speech or fair use either. And so YouTube has to try and navigate all of those difficult waters. Do you think they're doing a good job, Evan?
Yeah, I think so. I mean, first of all, I think that the implementation of the Content ID project, a program, whenever that was, 4 or 5 years ago, was really a watershed moment in this context or these issues. And I think, as we get further from that, we're going to recognize how significant that was in fostering platform, YouTube in particular, fostering as a platform where people are free to upload content, and the rights holders don't have to worry so much because they know they have options, easy takedown or quick monetization. The user doesn't have to be so worried that he or she is running afoul of copyright laws because there's a quick way to, the program provides the same mechanisms just from the other side of it here. So, I think that the whole approach to all this is good. And in general, the false, identifying false positives is an important adjustment to make in all this. It just kind of is funny from a theoretical standpoint because, I'm the furthest from being an engineer in talking about these types of issues and how to actually build, implement these algorithms to accomplish what it is that needs to be accomplished here. But it looks like there could be a funny opportunity for an infinite regress if you have a system that is supposed to identify infringements and then you have a algorithm tweak or either some countervailing system to identify false positives. Well, eventually, are we going to need another algorithm to check the false positive detector? So it just seems like there could always, be. I guess that's what is. It reminds me a little bit of a story. I don't know if we talked about it on the show or if it was just something I ran across a few weeks ago. I think it was on the show. There were, I think it was out east. It was like Maryland, maybe it was Baltimore or something, where they had the cameras to catch speeders, and people had been vandalizing those cameras. So what did they do? They put cameras to monitor the cameras to see who was vandalizing the cameras. So there those opportunities for recursive infinite regress are always pretty entertaining whenever they come up in the wild, and this seems to be one of them.
Yes. The constant, it's like looking in a mirror that's facing another mirror.
Yes,
yes. We will see how well Google and YouTube managed to tweak their system, but there certainly does seem to be an issue in how it's functioning now. It's sort of perhaps leaning too far over toward helping the rights holders pull things down that maybe shouldn't be pulled down. Speaking of trends away from piracy, interesting study released from an outfit called the NPD Group. They call themselves a leading market research company, and they have been doing surveys and research on how people are watching online video. And what they have come up with is that, traditionally, as you might expect, PCs or desktop computers were the primary means of doing that. It's now the case, according to this group, that online video is being consumed more on the television. And they say that web to TV video has, for the first time, surpassed PCs as the primary mode of consuming these files. Netflix Instant is the dominant application, so they say Hulu Plus and Vudu come in after that. I was actually surprised not to see Amazon Instant in here because they tend to be our online video source of choice in the Howell household. But overall, I think this is a really interesting development in the fact that, if you're watching on a service like this that is going to deliver web content to your DV, in all likelihood, that's not going to be pirated content. It's going to be content that people have paid for in one way or another. So I think, this is kind of an important watershed event. Do you agree, Sarah?
I'd say give the hackers some time. Every time you have new technology, someone figures out ways around old models and old technologies. But for now, I mean, it's definitely interesting to see where it's going to go. But I hope that people don't clamp down. Usually the knee-jerk response from the content industry is, whoa, let's stop everything. Let's try to control things. And it can be really problematic for developing industries.
What do you think, Evan?
Well, I just want to make sure that these data aren't just the same thing as recognizing that more computers have HDMI outputs or something like that, because it makes sense that people are going to choose a more visually a more a better human to machine interface to consume this content. So I guess I just need to think it through a little bit more to evaluate the issue you're bringing up, Denise. How does this play into the role of piracy? And I guess I would accept what you seem to be putting forth as a premise, that content that you get through perfectly legitimate services like Hulu, Netflix, Amazon Prime, and all that stuff. There's not going to be illicit in as much as it's infringing content coming through those services. And if that's going to be the primary mechanism for it to be put through a nicer display, a flat panel on a wall versus an iPad, a tablet or a laptop screen or something like that, then that would seem to support the notion that piracy isn't going to be much of an issue. And to kind of take what Sarah's saying, then it's going to be just the hackers are going to have to catch up with all this stuff. So
sure, I mean you could always
I have no idea.
Connect a computer to your flat screen and go from there. If what you want is torrenting on your big screen, but I just don't get the feeling that that's what mom and pop video viewer are up to. What do you think, Tim?
Anytime there's legitimate businesses that are being introduced and improving the experience for end consumers and creators get paid, then I think it's a great thing.
All right. Let us look at the graduated response system. Also a case where we could have false positives being a concern we were talking about earlier. There was a close look at the upcoming copyright alert system, Sixth Strike system, graduating to response. It gets all kinds of different names, but it is supposedly coming our way before the end of the year, and it is the agreement between the MPAA, RIAA, and several large ISPs to warn people if they are, being flagged by their ISP as potentially engaging in infringement. And there are various notices that come down, and various penalties can come into play as well. A University of Idaho law professor, Anne Marie Bridey, has looked at the program in depth, which is a very nice summary here in her report. I'm reading the report over on Torrent Freak. You can read all the stories that we talk about today over on our public discussion points page at delicious.com/thisweekinlaw/182 is our episode today. And she has some positive and negative opinions of the forthcoming system. Positively, she likes that people are given notice before anything too draconian happens to them. She likes that there is an independent appeal process. She doesn't much like how this has all been done behind closed doors, even though this is in effect going to operate like a law. Evan, did you take a look at this, and what do you think of Professor Bridey's opinions?
I did. I looked at it in a couple of things, a couple of observations here. I mean, first, the fact that this took place in secret, behind closed doors or whatever, that is unfortunate. And, wouldn't it be nice if we could have all been involved in the process? But I think the expectation that we could have all been involved in this process would be overly optimistic. I mean, this was a negotiated the negotiated establishment of a certain paradigm system program, what have you, between private parties that will have every incentive to safeguard their proprietary measures for doing all this stuff. So yeah, it's unfortunate that we all can't be able to shine our flashlights into all the companies' internal dealings that we interact with, but that's just not the reality in the marketplace. The second point would be, she made a big issue, rightfully so. This is a legitimate concern about the shifting of the burden of proof. It is a simple way of saying it. You're kind of guilty until proven innocent under this situation of infringement. Liable until proven not liable would be the more accurate way of saying it, since we're in the civil context here. And again, that's a legitimate concern, but it's one that I guess we really shouldn't be too surprised with, because this is all going to become a matter of contract law if you break it down to an essential perspective. By the ISPs are going to be amending their user agreements with their users to get your assent as a user of the as a recipient of the services, that you agree to be involved with all this stuff. It sounds a little bit like, by analogy, like the UDRP for domain name disputes and all that stuff. You got to be subject to these dispute resolution mechanisms, whether you like it or not, if as a condition precedent for receiving the service. The third observation I would make is to hearken back to a point that Terry Hart enlightened us on a few weeks ago on the show, when we were talking about Hadopi in France. The graduated response system that's been going on there for the better part of a year, maybe a couple years now, where the practical application of that has not resulted in widespread instances of people being cut off from the internet. In fact, it's a very astronomically small percentage of users who have even faced the beginnings of legal proceedings on that, which would demonstrate that the educational component and the goodwill kind of nicer relations between content owners and their consuming public is fostered in a way. So I get the professor's critiques on all this. I certainly see the interests that are represented in these critiques, but I can also see why the reality is that those interests were not perfectly met in the way that CCI has implemented the system. It's not a perfect world. That's too bad.
So, Sarah, we've got independent outfits monitoring torrent traffic and logging your IP address within 3 hours if you're torrenting one of the top 100 files. We've got the ISPs agreeing to notify potential infringers and penalize them under this copyright alert system. And we've got folks potentially, we certainly do have many more legal outlets available for people to, pay a small amount of money and get whatever movie or song that they want. Have we solved piracy? Is this it?
I don't think we'll ever solve piracy, because the content owners are always going to want more protection, more limits, more money for less money. They don't want to pay anything to get copyright registrations or get rights. So I think that even if you got to a point where we solve the problems now, people would find new problems to be concerned about.
And what do you think, Tim?
Well, I think piracy is still a huge issue. When I look at when I live in Nashville, I look at Music Row and I see how many songwriters used to be signed to publishing companies, and then how that number's been dramatically reduced. I see it firsthand. Jobs. Our whole economy is talking about jobs, and piracy is basically robbing creative people of jobs. So I think this is a really a great thing. I think there are people on the right who, or maybe I shouldn't use right and left, but there are people who believe in copyrights of people's rights and they don't want to violate them. And then there are people who are rebellious and just say, well, we want to sock it to the man. And then we've got these independent people who really maybe just are ignorant and don't know. And so I think from an education standpoint, this is going to be very helpful for those people that aren't on one side or the other. Maybe it'll help them understand, oh, well, you mean I'm not supposed to be doing this? For those people that already know they're not supposed to be doing it and it's fun, well, you're never going to solve that problem. They're always going to be looking for a revolutionary approach. So I like the fact that there's an educational component to this, and it gives people a chance. On the transparency issue, that's what the DMCA was. the DMCA was legislation that tried to include everybody in the discussion, and it was a miserable failure, in my opinion. We have some guidelines in place, but failure in this, from the standpoint of, yeah, we've got a system, and it's very clearly outlined how you're supposed to communicate, how you're supposed to take things down, how you're supposed to delete the accounts of repeat infringers, and frankly, none of that's happened. So I see this as we've moved out of this transparent dialogue, and now we've moved into the marketplace, which is what Congress wants things to. That's where things really get done. That's where our Congress says, hey, we've created this law. Now you, in the marketplace, figure it out. So that's what's happened here. We've got some big rights holders organizations and ISPs figuring it out. And I think it's great that they're working together to come up with a compromise.
So it sounds like you would feel like if the DMCA is not working, and I think I agree with you that the DMCA is not working, but probably for different reasons than you think. Do we need additional laws, or do you think that enforcing the ones that we have is adequate?
I think law is, I'm not a lawyer, so I don't think like a lawyer. I think laws are in constant need of revision. And when you put something in place and then mankind does a great job on figuring ways around and creating loopholes. That's just what we do, especially in a commerce-driven society. So it's going to constantly need to be monitored and adjusted to try to have opposing groups chime in, create a voice that creates a happy compromise. And generally in that process, one side or the other is not going to be happy. So I don't think we need more law. I think the law is going to be tested over time in the court system. And I think now that the Wild West is settling down and people like ISPs have recouped their billions and billions of dollars of investments, and in my opinion, on the backs of creative people, now they're willing to sit down and compromise. So they've got everybody on the internet, and they're making big dollars. And now now that they've made their investments back, they're willing to sit down and compromise. So, so I don't think we need more laws. I think we need this spirit of compromise to figure it out.
Denise, let me guess. You're upset about the DMCA because of the vessel hull design protection provisions. Is that what you're?
Yes,
you're upset
that
about?
one's always just rankled.
Yeah.
I think, on the one hand, it wasn't designed to evolve as technology did. The whole anti-circumvention aspect of it that protects DVDs, I think, is now, fairly archaic. That number one, it was cracked immediately. Number two, we're getting to the point where that doesn't so much matter anymore. That, yes, DVDs are still a standard and there are lots of them out there and they are sold and they are still a commercial market, but that's not the future. So I understand that, anti-circumvention applies to different copy protection methods as well. But, I've never been happy with that aspect of the law in any of its applications. And then the safe harbor part, the other sort of high profile, much more high profile than vessel hulls at any rate, that it doesn't do the job either, as we've seen with YouTube struggling with its algorithm and people trying to make the notice and takedown process work in a way that makes all parties happy. That doesn't really happen too well. So I'm not happy with the law in any of its iterations, except for the fact that it does provide the safe harbor. Without that, I think we'd see a whole lot of innovation, or we would have never seen a lot of the innovations that we see today. And we never would have been able to watch the songified version of the debate that came out this week, for example.
Yeah.
So, culture would have suffered greatly in the absence of the DMCA. Let me follow up, Tim, with one more question before we leave this. And this is something we explored with Robert Levine last week too, and that's the notion that piracy is responsible for the economic duress of the music industry. And I think I just heard you echo that sentiment as well. Can Can you flesh that out for me a little? Because as folks in the IRC are chiming in too, the economy's hurting in all sectors, and piracy isn't responsible for all of our economic downturn.
Right, because it's
so
PBS. PBS is responsible for our economic downturn.
That's right. So how is it that ill? I think the specific example you just gave was artists are not getting signed. Why would that be?
Well, a big part of it is when you look at the total revenue created by an industry, and when it's virtually cut in half. And I think the data shows that there's a direct correlation to the amount of piracy that was going on. So this isn't. I don't think it's really fair to say because the economy at overall that's the reason we've seen restriction or constriction in the music space. That's started back in 1998 and started in 2000 when the internet was beginning to boom. So my personal beliefs are that piracy have contributed dramatically to the reduction in revenues created by our industry. As a result of those revenues, people have lost a lot of jobs. There's a lot fewer artists getting signed. There's a lot fewer songwriters getting signed to publishing deals. So it's created constraint in the marketplace.
Okay, I think I understand your take on that. Let's move on now. There's been some really interesting stuff happening in the patent field, and let's take a look at that. Love our bumpers. Thank you very much. Let's look at what's going on in the Apple versus Samsung case, and specifically a couple of interesting developments there. Let's start with the jury foreman. Sarah, tell us what happened.
Oh my. Well, Samsung is arguing that it's entitled to a new trial for, among other reasons, that the jury foreman, who we've all seen talking to various news outlets and giving what seems like endless interviews, didn't tell the truth during the jury selection process, and specifically didn't disclose a case that it had against a company that Samsung has a financial interest in because he wanted to get on the jury. This briefing, it's nasty. It's one of the lawyers just filed a new affidavit today where he's saying, hey, we at Samsung didn't know what was going on, but Apple hasn't told us when they knew that he was involved in this other case. So the lawyers are not only getting very nasty about the jury foreman, but almost suggesting that each other, might be committing malfeasance. So this is really probably the most surprising thing we've seen in this case for a long time.
Okay, Evan, of course the parties were going to scrutinize the jury verdict and attack it in any way they possibly could. Do you think that this is just the first salvo that we'll see along these lines?
Who knows where this is going to go? This is, certainly a predictable opening salvo for an attack, for Samsung to make. It really underscores a much larger problem with the jury system. I mean, the idea that you could have members of the community, decide issues. And something weird happened with my video. Sorry about that. The fact that you can have members of the community get together and decide complex, factual, and to a certain extent legal issues is a nice thing in theory. But when it actually comes down to actually happening, that's much more of a challenge to think about. And we see all kinds of problems with the jury system being tainted with the use of social media and all this stuff. So there's that. For that reason, it's no surprise that some kind of weirdness would be going on that Samsung would look to attack in a situation like this. So it's a much bigger problem than what's exemplified here.
Okay, let's look too at the dissolution of the injunction against the Galaxy 10.1. This issue came back to Judge Koh, and she decided that Samsung could go ahead and sell this previously enjoined product. Can you shed some light on this for us, Sarah?
Well, again, Apple just had so many claims. So at the preliminary injunction stage, they're talking mostly about design patents. And Judge Koh said that, yes, the Galaxy Tab infringed this one single design patent. And the jury said no. So we have this jury verdict that's directly contrary to her finding about whether or not there was likely infringement. And she said, based on that, I've got to dissolve the injunction. Apple, of course, is not very happy because they're saying, one, we should have won on that claim as a matter of law. And two, well, the jury found it infringed as other patents. So this story is definitely not done.
Has Samsung taken any affirmative steps on this that you know of?
Affirmative steps in what respect?
I mean, can you go out? Yeah. Are they marketing? Are they selling immediately?
Oh, that's a good question. I'm not sure. Obviously, they've still been on sale because the retailers weren't enjoined. Just Samsung was enjoined.
I see. So, Evan, were you surprised about this one at all, that the Judge Koh would go ahead and do away with the injunction in light of the jury verdict?
I don't know whether to be surprised or not. I don't have enough insight on it. I guess one of the reasons I didn't, haven't cared too much is that, this is an older model anyway, kind of like with the Galaxy S3 being what's really the hot selling product for Samsung now. It's just kind of like these are just little nuanced variances on things that really are so passé at this point. Kind of like the YouTube or, Viacom versus YouTube case. It's all about infringements that happened in 2005. I don't care.
Yeah. But you got to remember the battleground is not just the Galaxy Tab though, because usually these injunctions read this product plus anything that's not colorably different is enjoined. So that gives Apple wiggle room to say, well, yeah, this newer product is actually not colorably different than the Galaxy Tab. So that's where the battle's actually going to be.
Wow, no wonder those patent lawyers just do nothing but file motions all day.
Yep.
Once in a while you get to the merits, but there's always something to file a motion about in the meantime.
Yep.
Right. All right. Well, speaking of design patents and your specialty, Sarah, I'd like to introduce you to Barack Obama here sitting behind me in a Navy chair. Why are we talking about Navy chairs and why is there a relation between design patents in that context and the ones that we talk about in the technology arena?
Well, of course, design patents aren't technology specific. You can get them for furniture just as much as you can get them for handheld computers. Actually, the furniture industry has been using them for years very effectively. Now, this new case with the Navy chair, there's a company and they've been making these chairs for the Navy for apparently 60-some years. Very strong, they can survive life on a carrier, allegedly, torpedo hits. So these are very heavy-duty industrial products. And Restoration Hardware started selling something that looks the same but isn't made to the same specifications. It's actually more appropriate for your house. At least here in Oklahoma, we're not expecting to get hit by tornadoes anytime soon. And so this company called MCO filed a lawsuit this week. And it's just been really fascinating to see because every law professor, every legal expert I see who looks at it says, wow, that's kind of a weak case. And every designer I've seen has just been livid. They are just outraged by Restoration Hardware doing the same design. So it's been a really fascinating case, and it'll be interesting to see where it goes.
So is Restoration Hardware the first and only person to have knocked off this chair? It seems like chair designs are fairly liberally copied.
Well, if there's no copyright or patent, they should be able to be copied, right? The interesting thing about this chair is I can't find any evidence that they ever had a design patent, but this company knows what they're doing. They actually have a number of design patents on other chairs. And the facts here are really interesting because if they had gotten a design patent in the 1940s or whenever they're saying they made it, it would have expired a long time ago, right? So they've already had exclusive use as far as we can tell. They're saying their use has been substantially exclusive. I have no proof to the contrary. But if it's true that they've had 60-some years to use this design, clearly asserting trademark rights, which is what they're doing, contravenes the design patent scheme and this idea of a limited times bargain.
Got it. Well, we'll go ahead and make Navy chair our first MCLE passphrase for the show. And before we go on, and since we're talking about patenting chairs, we're going to talk about patenting pants. But before we do that, I want to go ahead and thank our sponsor for this episode of This Week in Law, which is ShareFile. Of course, when we're working, we need a professional, easy way and certainly a secure way to send and receive large files, to share documents and other materials with clients and colleagues to increase productivity and get things done. That's why I highly recommend ShareFile by Citrix. It's the tool that millions of professionals rely on every day. ShareFile is a file sharing solution for businesses that's easy to set up, easy to use, and completely under your control. Files can be password protected and time limited. You can see that they've been received and modified, and files can be accessed from anywhere, any Mac or PC, tablet, smartphone. I can tell you, as a lawyer who constantly uses technology in my practice and communicates electronically with clients, I can't remember the last time I sent an actual paper letter or used a messenger to deliver a sheaf of documents. Just doesn't work that way anymore. But because we still have large files to send, and oftentimes now they're large media files, we need a way to get those things around safely and securely. And using ShareFile in my practice has been absolutely the greatest solution for that. I use ShareFiles to get documents out for review and revision. I use ShareFile to make sure that things have arrived at a place, and the party on the other side can't say, "Hey, I never saw that," because I can know if they've seen it. I want you to try ShareFile with my special offer. You can sign up today and receive a 30-day free trial. To do it, go to sharefile.com, click on the radio microphone, and enter TWiL, TWiL. Remember, visit sharefile.com and type in TWiL. Thank you, ShareFile, for your support of This Week in Law. All right, Sarah, if we can patent chairs, can we patent pants too?
Yeah. So I've been watching patented pants for a while just because this Lululemon case, I don't know if you've talked about before, has gotten a lot of attention. Their case against Calvin Klein for their patented yoga pants. So I've been kind of following it just almost as a joke because it's really fun. It's also fun to see like the ones I tweeted this week where the artist appears to have failed life drawing class and you just don't really see how that would fit on a human being. So, yeah.
It kind of, let's see if I didn't put the photo in our rundown, but let me see if I can get it to the studio so we can put it up for you. They kind of look like jodhpurs.
Yeah, a lot of the cited references were to harem pants, that sort of thing.
Yes.
I don't know. There's clearly interest in the fashion industry and design patents, but I just don't know who that's supposed to fit or how. But
right.
I'd love to see a model. Maybe we should claim by photograph so we could see that.
So there's no requirement in patent law that the designed product actually have to fit a human being. It could be designed to fit some sort of alien species and still receive patent protection.
It could be. It could be. I'm just wondering, it's going to be hard if there was actually infringement. How do you tell if what's on a person infringes that or not? I'm not really sure. So hopefully that one won't get litigated, although it would be funny if it did.
It would indeed.
Yeah, especially if one of the claims are that they make you look attractive, because that would, it might belie the fact, if you look at the actual file. So.
Right, that's their utility. Well, we've been kind of going around this issue. A couple of big heavyweights in the worlds of legal writing and legal scholarship this week posted over on the Becker-Posner blog. You worked for Judge Posner at one point. Is that right, Sarah?
Yeah, I was an academic research assistant for him while I was in law school.
That's right. Well, he has made a number of interesting comments and arguments over the year here about the scope of existing copyright and patent law in the United States. And both the authors of the Becker-Posner blog this week posted their takes on copyright and patent reform, both of them calling for thinkers and legislatures to get on that program, with Judge Posner specifically saying that fair use is not getting a fair shake and that the length of copyright is just completely out of control. Do you have any further amplification on this, Sarah, or any further insights having worked for the good judge?
Well, it's interesting because a lot of points that they brought up, the Legal Academy has been talking about for years. If you talk about any copyright professor, they think the copyright term extension was nearly criminal. just unjustifiable. But the nice thing about Judge Posner is that he has this credibility as a national sort of intellectual figure to bring a lot of these issues to light. So I think it's good. I think he should be bringing this up. It's provoking debate beyond just academia's walls. So I'm all for that.
All right, Tim, do you have any thoughts on copyright reform? Are you pretty happy with the way it exists now, or do you agree that perhaps things could be rejiggered a little bit and all parties involved would be better served?
I think that if any kind of law typically is going to get out of balance when you've got commerce behind it, like I said earlier. So I think what will happen will probably be positive for copyright-related industries if there's a negotiation to take place that the terms be reduced, and maybe there'll be some compromises on other areas of the law that are in the benefit of creators and copyright owners. So, yeah, I think I would agree that any law, including copyright and patent law, is going to have to be adjusted and be reformed over time.
Yeah, that seems to be an area of common ground on both sides of the, say, the rights holder fence on one side and the technology user fence on the other side. That metaphor didn't quite work, but you understand what I'm saying. That reform is in order, and we should be thinking about it. Evan, are you surprised at the consensus that we're seeing along those lines?
No, because I think these are perfectly reasonable, especially from a moderate point of view, being able to see on either side of this issue here. I spend a lot of time thinking about how copyright law could be improved, and I frame that discussion and those thoughts in terms of how we better suit the law, which is an abstract set of principles and concepts to deal with the real and concrete and specific situations that are the new ways that people create content and distribute content and consume content. So, it's the consensus ought to really, be there. If we think about things as elementary as, what the term of copyright should be, it's just so long. And it appears, from the things that went on in the 90s when the last extension went on, that there were some special interests that were driving that steamboat in a disproportionate way. With too much disproportionate force. One of the big concerns that I have is taking the emphasis off of copying as the primary thing of the right that should be had under Section 106 of the Copyright Act, and making that more into reality of how content is distributed and consumed on the web. It should be more of an access right. And then finally, we've talked about this in some recent episodes, especially in light of the Jamie Thomas decision in the Eighth Circuit. The statutory damages provisions in the Copyright Act are just way out of whack when it comes to what really should be there to make content creators whole. So I saved that one to point number 3 because that would be the most likely point of deviation between the two sides of this. The content owners say, yeah, we want statutory damages there to be able to punish people, whereas the folks who want to trade files will say, oh, no harm, no foul. I should pay, 99 cents for this song that I, traded but didn't pay for. So there's plenty of room for consensus, which is, of course, a positive thing. And, it's got to happen, and it will happen inevitably, because otherwise you just never have seen historically where the law fails utterly to keep up with the needs of the society that it serves. So we'll figure it out one way or the other.
I have to say, I'm a lot less sanguine about the chances of politically us being able to decrease copyright term anytime soon. I'd love to see it, and that's why I hope this public debate, but we're going to need a lot more public will, because Steamboat Willie, which is why I was laughing when you talked about the steamboat, is going to be up again. And I was just at a conference where someone was saying that Mexico just extended their term to life of the author plus 100 years. And if you don't think Disney's going to be telling Congress about that, there's going to be pressure. Because as long as there's somewhere in the world where they give more rights, people go to Congress and say, hey, we're being disadvantaged. Because Mexico has 100 years, we should have 100 years too.
So they'll threaten to take Disney World and Epcot Center and everything and move it to Mexico, and just think of all the tax base we'll lose. So yeah, that's how they're going to do it.
But you could combine your Puerto Vallarta vacation with fun with the kids. So how could that be a bad thing? All right. On the one hand, we have Gary Becker and Richard Posner pointing the finger at our creaky and antiquated legal regimes in the copyright and patent arenas. On the other hand, the Federal Circuit turned 30, and over at Ars Technica, Timothy B. Lee has basically tarred it with wrecking the entire patent system. That's his headline over there anyway. Sarah, you say in your academic circles, this is quite the article this week.
Oh, and not just academic. This is the one that the patent practitioners are up in arms about. Because, and I think this is one good point he made, patent practitioners have this sense of ownership over patent law that I haven't really seen anywhere else. You know, where they know better than the Supreme Court. It's their law, and they are just angry about this. All this week on Twitter, it's been talking about this article from one view or the other. So this has definitely hit a nerve and exposed some issues that like I said, people are just angry on either they think this is great or they think this is total, you know, what's the word I'm looking for? You know, it's just like heresy, right?
Right. So,
that was a nice word.
Bring us up to speed. In what way is the Federal Circuit, according to Ars Technica here, responsible for the patent mess that we find ourselves in today?
Well, one of the express purposes when Congress made the Federal Circuit is they wanted to add more uniformity and, frankly, to make patent law stronger, because the circuit courts were very skeptical of patents. They were invalidating them at a high rate. So they created this court to deal with it. And I think the judges that came on, Judge Giles Rich is one that didn't get recognized. He was the first patent lawyer to be on the Federal Circuit, and he is currently viewed almost with saint-like status among some patent lawyers you talk to. And the court from there on, they not only made patent law more consistent, they made it stronger, they made it more patent owner friendly, lots of changes. And I think that's what this article is mostly about, was just making these powers so strong, these rights so strong that they ended up being crippling. And then also just the ignoring the Supreme Court side of it, which is always very interesting.
All right. Evan, any thoughts on the Federal Circuit?
No, you know, I guess I would visit it if I was hanging out in Washington, D.C. So I don't know. The only time I think about the Federal Circuit is as the Court of Appeals above the Trademark Trial and Appeal Board, which is such a small part of its docket. I don't think of it in terms of patent law that much, as far as, you know, my everyday the practice goes. So, you know, and it was cool that Ronald Reagan kind of created it. And I guess that's all I got to say.
I argued a case there once, but I'm not a patent lawyer. And yeah, I did.
Were there some copyright issues or something in the case and involved some patents, or what was it about?
Yes, exactly. And we did not fare well before the Federal Circuit, unfortunately. But it was fun to go to D.C. But it's not my usual stomping grounds, not being a patent lawyer. All right, let us move on and look at some issues that we've been talking around this for the whole show as far as reforming law. But let's see what the folks in Washington may be up to these days along those lines. All right, so we've got on the one hand, the technology industry coming together and really deciding that, you know, we have not had our voice well represented in Washington historically. They have a new lobby. It's called the Internet Freedom Lobby, and they are planning to remedy that as soon as they can. They've got Amazon, Google, Facebook, and others, 14 groups and in all. Again, this is from David Kravitz over at Threat Level. Going to Congress and the Senate with their agenda. And they basically were mobilized by the legislation that was proposed earlier on this year, COICA, which became SOPA and PIPA. And now they have a stronger voice, they think, to be able to combat that. And then On the other hand, we have, I thought this was really interesting that Chris Dodd, who is a he's a senator, I believe, or was a senator before he became the head of the MPAA, very vocal and present during both parties' political conventions, and thunderously clapping both parties on the back about their platforms, both of which mention somewhere in the fine print that intellectual property rights are important and need to be protected, and this needs to be something watched by lawmakers. So I just thought that this was an interesting dichotomy here, even though we're not hearing so much about the technological hot button issues in an election year. That's not stopping the folks on both sides from going to the Hill and being vocal about them. Evan, what do you think about all this?
What else do both sides have to do but go to the Hill and be vocal on it? Especially if it's not a big deal. So sure, so the whole idea with Chris Dodd, saying good things about the GOP and the Democrats, that to me that just underscores how fluffy all this talk is anyway. And it's fluffy all around because, the Democrats can say, anybody can just sit here and say, and you can please almost anybody. If you're way up there at the general level and you say something like, we believe in a body of regulation that fosters both innovation and creativity, but yet recognizes the principles of an open internet and also satisfies the interests of the stakeholders all around. So, that's just, you can just go on ad nauseum with fluffy stuff like that, and you're going to make everybody happy at some point because all it is striking balances. And I admit I'm guilty of just trying to do that in my thinking, like, well, what's the middle ground and all this stuff. So, this is fine to do. It's fine for Chris Dodd to say whatever the heck Chris Dodd wants to say about this stuff. It's fine for the Internet Association to say whatever it wants to say. What else would you expect from the Amazons and the Facebooks and the Googles of the world? Why would we be surprised? Because it is, just as you said, Denise, it's an agenda. Everybody's got their agenda. Everybody's got their horse in the race that comes from a certain perspective and will be maximized. The profits and revenues will be maximized from, to the extent that agenda can be put forward here. So at the end of the day, there's not a whole lot that we can really learn from all this talk up here at the cloudy general level. If we really want to take this stuff seriously, we've got to be thinking about more ways to actually affect people's norms in ways that we'll be able to implement practical solutions that actually do strike the balance. What should the legislation actually say in response to SOPA and PIPA? You don't hear a lot about that. All you hear is just throwing rocks at SOPA and PIPA. How are we actually going to craft something that's going to meet the needs where the rubber meets the road? That's the important pursuit in all this.
Right. I guess it's just interesting that, both sides of the issue have definitely lined up and taken aim at Washington, and seem to be more ready to deal with whatever the successor to those proposed bills may be. Tim, where do you think we're headed on all this?
I really don't know. I see. I know where I would like us to be heading. I'd like us to be.
Where would you like us to be heading?
I would like us to be heading down a real focus on creating jobs for creative people, and focus our laws on protecting creative people, because our economy is in a slump. Everybody talks about jobs, and since half of us are more right brain and half of us are more left brain, it stands to reason that there's a huge chunk of the population that is a more creative person, somebody who can output photographs, music, written documents, sound recordings, film. And this is driving a huge sector of our U.S. economy, and it's probably the most important export of the U.S., and it seems like it's kind of getting lost. It's intellectual property. Yeah, I support intellectual property, but I don't. It used to be when in the old days we created a navy to blow ships out of the ocean who were stealing our goods, And we've just taken kind of a lackluster approach toward theft of the goods and services of creative people. And so I wish there was a much more passionate position that our politicians were taking on intellectual property.
I blame Restoration Hardware and the knockoff chairs.
Yeah. Yeah, the Navy used to mean something, obviously. So.
Yes, I guess no
Tim,
more.
Tim, on that point, I mean, that's that it's who can be so unpatriotic as to say we shouldn't care about things like that, and the livelihoods of people. But I mean, I think the thing that concerns me is that using the term theft is such a byword in my book because it overstates or actually mischaracterizes what really is going on. I've said this so many times on the show before, and I say it a lot. It's infringement is not like theft. It's more like a trespass. So it seems to me that the argument, the IP maximalist argument loses a lot of credibility in the minds of more moderate people and the people on the other side of the argument with hyperbole like that, because when the thought is taken in such an extreme way, it seems then to minimize the risks of taking such an extreme position. The risks that SOPA and PIPA had to the infrastructure of the internet, for example, of privacy interests, and tracking down infringements, just the overall stifling of things like fair use and remix culture. And so, I don't really know where I'm actually getting on this, other than to just comment on, my antenna always goes up whenever somebody's going to characterize it as theft, because I'm really interested in learning more about what the interest at stake it really is there that's making people characterize it with such powerful imagery of theft. Bandits, black masks going in under cover of darkness and walking off with things, putting them onto ships that should be getting blown out of the water. It's just really, really something.
So you would think someone like a Kim.com is trespassing on the rights of creators when he enabled and obviously personally benefited to the tune of millions and millions and millions of dollars. That's trespassing?
Well, you can't try to diminish the harmful impact of what happens in situations like that. When I'm saying that it shouldn't be characterized as a theft, I'm not saying that it should be that any lesser liability or lesser responsibility should necessarily attach. It just seems like we could all have a more meaningful conversation about it if we could agree on the actual legal framework that is most appropriate for discussing it. Because Thomas Jefferson himself very famously talked about patent law. When using the metaphor of lighting a candle, somebody else can light their candle off of your taper, and your light isn't taken away, but the light is doubled. It's the same way with copyright in particular. You can copy something, and it's not like you are dispossessed of anything. Maybe you're theoretically dispossessed of a future revenue stream, and that's something that the law should step in to address. My essential point is just characterizing it using the appropriate metaphor from other areas of the law so that we can move together as a culture, as a society, to really put meaningful reform in place rather than just so much hyperbole that is entrenched in not the appropriate metaphors and nomenclature to talk about it. That's all I'm trying to say.
Yeah.
Kim.com's a bad guy. He shouldn't.
Yeah, I think there are plenty of examples of things that are probably where theft would be hyperbole. But when you use an example of where blatant infringement is occurring and millions of dollars, it's theft. That's black and white. It's theft. So I don't think that's hyperbole in that case. But I agree with you. I see lots of people who aren't able to, or we aren't as a group able to reach consensus because we're making dramatic statements. So I don't want to be guilty of making overly aggressive statements. But when I personally am thinking about people like Kim.com and those blatant infringers, it's a casual innocent person who doesn't really understand, and they're sharing it with their friend. And then those are the people who are going to hopefully benefit from an educational process that the associations and the ISPs are agreeing to. So we'll eventually get there. But I don't see our politicians taking, I've heard just it's been an exception and not the norm, where somebody takes a strong position that, hey, people are losing their jobs over this kind of, I'll continue to call it theft, because it's actually a displacement of revenue. I mean, people are not getting paid for their work. So I do get passionate about it. I hope we're all working together towards some sort of resolution of this significant problem.
Well, one area that there is, and by the way, Tim, we should have warned you that Evan studied philosophy, and I'm hearing his inner philosopher come out in these comments. So bear that in mind.
Maybe just getting too semantic.
One way in which folks are trying to forge ahead and make new laws that relate directly to revenue, although I'm not sure that it's about preserving revenues for the creators in this instance, is under a new proposed piece of legislation, and that is called the Internet Radio Fairness Act. I'm afraid my video froze here. Sorry about that, guys.
We can hear you.
We'll
just
restart
fine.
it. Yeah, we'll restart that again in a second. In any event, this has been much on the radar of anyone who is a Pandora subscriber, because Tim Westergren, the founder and CEO of Pandora, is definitely behind this act. And it's sort of bringing back, if anybody remembers back to the early 2000s, there was a lot of talk about internet radio royalties and how they are structured in a way that does not reflect or parallel terrestrial radio royalties. And we were very concerned there for a while that internet radio stations were going to have to shut down because the royalties that they were forced to pay were so crippling. And ultimately, there were some compromises reached and some tiering based on revenues that seemed to solve the problem, but not according to Pandora. Pandora would like to see some more reform. I'm sure that other internet radio folks would like to see more reform too. Of course, Pandora isn't the only possible internet radio service out there. There are lots of others. And Bob Lefsetz sort of took Pandora to the mat. Tim, you're probably a reader of Bob's. If you're given your industry, he tends to throw stones at things that he doesn't like. And one thing that he didn't like recently was this open letter from Tim Westergren rallying subscribers of Pandora behind this new reform law. He thinks that it's just an example of a CEO being self-interested and trying to enact laws that will only benefit his company, won't help the users, won't help the creators. It'll just make it easier for Pandora to do business. I don't think I agree with that because, of course, if the law does pass, Pandora won't be the only company benefited. Other competitive services that maybe operate better and do the job better than Pandora does might only be possible if there is royalty reform here. So here's a concrete proposal that's pending now, and I'm interested in what you guys think. Tim?
Well, to be honest, I'm not familiar with the ins and outs. I got a copy of the letter. I saw this, but I'm not familiar with all of the nuances of this proposed legislation. And maybe I can let someone else comment first, because it seems like the highlight for me was about not reducing their royalty payments for performances related to musicians. That could be wrong, but I'll let somebody else comment first. And if that is part of the meat of this legislation, then I do have some comments about it.
Sarah, have you looked at this at all?
I haven't been following this closely, no.
Okay, how about you, Evan?
Well, if I were to sit here and say that I understood the nuances of Section 114 of the Copyright Act, which is what talks about the payment of royalties for webcasting and streaming audio like this, I'd be lying, because there's really not a person on the face of the planet who understands all that BS that's in Section 114. There is another example of some crazy lobbying and special interests that enacted a crazy looking Frankenstein of a law. So as far as the Lefsetz Westergren issue, I mean, I have a feeling there's something personal going on there, because I don't know why Bob Lefsetz is picking on Tim Westergren so much in all this. Because sure, Pandora is going to be looking out for its interest. Seems to be another theme of this song. Imagine that companies and associations are going to look out for their own interests. Why is that so shocking to anyone? So I can see where the criticism of Westergren is appropriate, in as much as he's trying to be duplicitous to his users, but I don't think he's trying to be duplicitous. I think the blog post that Pandora put up is very transparent and pretty straightforward as to why they're looking to reform the Copyright Act here to equalize, to make it more in line with what terrestrial broadcasters have to pay in order to deliver music to people. It bothers me that the law would be set up in a way that certain sectors of the industry may have higher barriers to entry than other sectors of that industry because of the nature of the technology that they're wanting to use. And that unfairness seems to become more and more poignant as we go through time here. And that more people are consuming content, audio content, through streaming media over the web, through their mobile device or whatever here. So I think it's perfectly appropriate for there to be legislation like what has been introduced here by the congressman from Utah and Jared Polis from Colorado, and then Ron Wyden in the Senate is sponsoring an identical bill over there. It's perfectly appropriate to level the playing field so that streaming broadcasters over the companies who are streaming content over the web like this are pay a similar proportion of their income as what terrestrial broadcasters do. It's not necessarily like I'm obligated to disclose this, but it does kind of animate my position on this. I've represented more than one streaming webcaster, which was neither one of them were Pandora, and right. So that goes to your point, Denise. This is much more than Pandora involved here. This is opening it up to a broader range of entrepreneurs. And it seems like if we're interested in business and enterprises having the opportunity to enter the market, especially innovative people, the kind of people who start up these types of services, then the law ought not to treat them unfairly to the benefit of more the incumbent players, those behemoths that are the terrestrial radio companies. I was thinking of a bohemian behemoth, and I was making a portmanteau there. I'm a behemoth that wears like a beret or something.
Little soul patch.
Can I add something on this? I don't know if most people are familiar with this, but the U.S. and China were the only two countries in the developed world that did not pay a performance royalty until recently to artists and musicians on sound recordings. The people who were getting the performance royalties from ASCAP, BMI, CSAC, and their equivalents internationally were the songwriters. And we in the U.S. Had strong lobbying power, and where the rest of the world signed a treaty to pay the artists and the musicians, we excluded that section. So now it's there's a lot of dialogue occurring about trying to figure out so that we don't make this mistake going forward in this. Now we're moving away from terrestrial broadcast. Now that we're moving into digital broadcast, we need to correct that mistake. And I don't have any problem with Tim Westergren stating his case for his company. That's what he should be doing. And then we'll work it out in Congress, trying to come up with a compromise. But I do think it's an opportunity, and I don't think they should be paying a larger percentage of their revenue or disproportionate percentages. But I think some of the nuances are related to the fact that there's more people that should be paid now, and we're going to have to figure it out. And I don't think it should be put on the backs of the technology companies. There's going to have to be some compromise here. There's a percentage of the
you think
pie.
that? I'm sorry to interrupt. Do you think then? I mean, if the crux of what Pandora wants to do is bring internet radio into line with terrestrial radio, you're more flipping that on its head and saying the royalty structure in terrestrial radio isn't cutting it either.
No,
and
it's not
there should be
compensating
consistency,
all the
but the whole
players.
thing needs to be rethought.
Yes, there needs to be, and it's already happening. We, several years ago, we created an organization called Sound Exchange, and that's one of the only growing organizations in the music business. Its royalties that it's collecting is growing, and it's paying those people that haven't historically been paid any performance royalties, producers and engineers and musicians and recording artists whose performances are embodied on these sound recordings haven't, in the U.S., received a share of these performance royalties collected by ASCAP and BMI and CSAC. So there's a shift occurring, and I know that's caught in the crosshairs of, my guess is it's caught in the crosshairs of this legislation. And it's just going to force the hand. I think it's going to force everybody to make the necessary compromises that are needed to get these creators compensated like the rest of the world is compensating them.
So let's move now to our resource and tip of the week for you folks. I think I mentioned that our second MCLE passphrase for the show is the Internet Radio Fairness Act. Let's just be clear on that point. And then move on to our resource of the week, which I really love. It is called The Illustrated Guide to Criminal Law. And calls itself The Complete Law School Course That Keeps the Laughter in Manslaughter, which is just the best promo line I've ever heard. Boing Boing also, too, points to its companion Tumblr site. I guess it started out as a Tumblr site, and then they got a book deal and calls it a complete first-year criminal law course in comic form in 17 parts on Tumblr. And the reason I'm putting this out as our resource of the week is we constantly get questions from viewers and listeners on points of criminal law, which frankly, Evan and I don't know that much about. We, took criminal law and criminal procedure in law school, but we don't practice it. So to fill in your gaps in knowledge about criminal law, and of course, there are all sorts of misconceptions that we all have, just sort of common urban legends out there, that this book humorously debunks and sets you on the right course. So this is our resource of the week, and I think it's a great thing to bear in mind. Evan, did you get to take a look?
I did. And, the thing that I think is most important about this, and not just in criminal law, but all areas of law and civics and politics, is that government should not be anthropomorphized as the Leviathan or Uncle Sam, but, like a badass chick, like Lady Justice, like the Greeks got that. That's the most important thing. I think we can all understand things a lot more if we start from, if we operate from that starting point.
Yes. I prefer to think of it as a bohemian behemoth.
There you
with
go.
A little soul patch.
Right,
exactly.
Right. That's the kinder, gentler nation.
Yes, exactly. And then our tip of the week is if you're out at the Pebble Beach golf links and you see their famous cypress tree, go ahead and take its picture. I guess this is something that surfaces every now and then, and I've seen iterations with this walking around zoos that have posted, you may not photograph the animals, and this is not like out of a health concern, it's out of a copyright concern. This was written up over at Tech Dirt. And before that, it's been written up in the New York Times. And the notion is that there is some signage, I guess, next to the famous cypress tree that is the trademarked logo of the Pebble Beach, the overarching organization that owns Pebble Beach, the Pebble Beach Association. That they say that the tree photos of the tree or other depictions of the tree cannot be offered for sale without the express written permission of the Pebble Beach Association. And so folks are worried, how can somebody possibly expect to copyright a tree or prevent you from photographing a part of nature? Over at Tech Dirt, Mike Masnick does a good job of outlining how this is not a copyright concern. You should be able to photograph the tree just fine and draw it to your heart's content and even sell those things. Because even though contractually you may find fine print in your agreement with the Pebble Beach Association when you visit to the premises, that this is actually a trademark, and it would be very difficult for a photograph or a drawing of this cypress tree to actually be confused with the trademark. So just debunking that, go ahead and photograph trees all you like. Sarah, I was wondering if you had anything to add to this particular notion.
No, I thought it was a great article because there are so many misconceptions and people get confused between copyrights and trademarks. So I was very happy to see a cogent and helpful explanation.
Yes, it is well done. Thank you, Mike. And that's going to be our tip of the week for the week. And this has been a really fun episode of This Week in Law. I appreciate all of you joining us today and the disparate opinions of our panel. Tim, it's been great to hear from you and to hear about your company and the work you're doing over there in Nashville.
Thank you for the invite.
It's been good fun. Where can folks reach you other than at myworks.com, which they should check out if they are concerned with managing their copyrights in creative works? Where can they reach you online?
I know
you have a couple I found at least 2 different Google Plus profiles for you.
Yeah, I have an individual, and then I have a one I use for business hangouts. So the best way to reach me is Tim Smith at MyWorks. Okay.
Not over there on the Twitter?
I do have a MyWorks Twitter account. I'm mostly sharing articles from that and a few little tidbits here and there. So, but the best way to communicate with me is Tim Smith at MyWorks.
That's great. Thanks so much, Tim, for joining us today.
Thank you.
And Sarah, it's been wonderful hearing from you.
Thank you for having me.
So I hope you continue to spread the gospel to your students over there at Oklahoma College of Law. And I know you're design_law on Twitter. Anything else you'd like to share with us or promote before we sign off?
Nope. If you have any questions, you can look at my profile on the University of Oklahoma website, and I'd be happy to answer any questions or talk about any of these topics.
That's wonderful. Thanks so much, Sarah, for joining us. Evan, it's been way too long. I'm so glad we got to do the show again today.
Me too. It's great to be back. Really have enjoyed it. Tim, great to talk with you. Really enjoyed our conversation. So glad we could connect and talk about these things on here. You know, it's great stuff your company's doing. So I hope people check that out and learn more about my works. Sarah, great to talk with you. I know that you worked in Chicago for a while, right? I think you were right across the river from me. Weren't you at Kirkland for a while before
I was,
going into academia? So. Yeah. Are you like from here, or did you spend any time here, or
Well, I went to school there, stayed. I love Chicago. You ever need a speaker? I'm always up for excuses to go back and visit.
Right on. So yeah, great to talk with you. Glad we could connect. And Denise, thanks for hosting a great show.
Thank you so much. And Sarah, I believe you're our first Okie, albeit a transplanted one, on the show, so you have that distinct honor. All right. Well, sorry.
Hopefully I won't be the last.
Hopefully not the last at all, no. Let's just let people know that speaking of Google+, we do have a page over there and on Facebook, and we use those to brainstorm ideas for the show, hear from you guys. Also on Twitter, I'm at D. Howell. Evan is at Internet Cases. You can hit us up in any of those places to let us know what's on your mind. If you want to add points to our discussion, we love hearing from you. You can also email us. We're Evan at twit.tv and Denise at twit.tv. We record the show every Friday at at 11 o'clock Pacific, 1800 UTC at twit.tv. So we're thrilled if you tuned in live just now and watched us. Or, of course, if you'd like to find us after the fact, you can find us on iTunes, on YouTube, and at twit.tv/TWiL, where the entire archive of shows exists. And we're really looking forward to seeing you next week, we hope, when we resume our discussions of technology and the law. Until then, take care.